All right, I think we're ready to get started. And so, good afternoon, everybody. My name is Zach Mundy. I'm the director of the Graduate Student Legal Aid Office, and this is part of our GRadulting Workshop series. We're lucky today to have Felicia Metz with us, who is an attorney and the director of Ventures here at the University of Maryland. She's a licensed attorney as well as registered to practice in front of the USPTO and has been with Ventures for a number of years and advised hundreds and thousands of students on these types of issues and has been a great resource for us in the past. And so we're very happy to have her here today. Feel free, if you have any questions, to just put them in the chat and we can try to catch them when they pop up, or maybe if we miss it, we'll try to check them at the end and have Felicia answer any questions that pop up. But thank you for being here today with us, Felicia, and feel free to begin whenever you're ready.
Great, thanks so much. I've also invited my colleague Shantae Hallett, who's another attorney in my office. Shantae also works on a variety of agreements and contracts for the university and also deals with all the agreements with sponsors and mentors for our experiential learning courses on campus. So thanks, Shantae, for joining too. I'm going to keep this pretty high level today, just do some basics on IP, talk about types and rights, a little bit about our IP policy so you can figure out the work you do on campus, whether the university has an interest in it or if you own it personally, or a company you're working for may own it, and talk about some of the resources available for you as you're going along in your research and your careers. My office, Ventures, we are the technology transfer office for the university. So we manage IP that the university owns. But certainly if you ever have any questions, even if it's not something that the university owned, we're a resource available to you as well. So into the different types of IP. So trademarks identify the brand name or logo, and the purpose is that it lets consumers know the source of goods or services. To have a valid trademark, you have to have some sort of use in commerce, and you also have to meet some other criteria. You can't register words that are, for example, generic. And you can lose trademarks as well if your mark becomes so widely used that it becomes generic. One example I like, escalator used to be a registered trademark, a trademark for escalator brand moving stairs, and then it became a verb or a noun, and now is no longer a registered mark. I know there was a question ahead of time about how you go about registering a mark. So you don't have to register a trademark to have some protection around it, though you do get a lot of benefits. And registering trademarks, it's a country by country requirement. Ours are registered through the United States Patent and Trademark Office. There's a registration fee you have to pay, some other fees depending on where in the works your mark is. So are you actually using it in commerce yet, or do you just intend to use it in commerce? Before you file an application for a registered trademark, it's important to do a search to see if something already exists, if there's going to be confusion in the area, if somebody has a similar name for a similar type of good. So I would recommend finding an attorney who can help. At the end, I'll include some resources too for some pro bono services that could be helpful in registering a mark. It's relatively inexpensive, $300 something to register a mark per class. Though if you want, coverage over lots of different types of goods, then you have to pay for each area. Trademarks can last potentially as long as you have use in commerce. There's no limitation. You do have to pay renewal fees, though, every 6 years and submit evidence to the USPTO that your mark is still being used. But it's a relatively straightforward process. Here at the University of Maryland, we have marks as well. There's our muscular testudo. If you ever see a little R in a circle, that means there's a registered mark. If you see the little TM, kind of in superscript, that usually means that someone has a mark that they're trying to put the public on notice that they think they have some trademark protection, but it might not be registered yet. So if you have something and you want to start branding it, you can do the little TM. Copyright protects original works of authorship in any fixed tangible medium. Copyright, though, does not protect underlying ideas or functionality. You also don't have to register copyright. Copyright attaches as soon as you write something down, as soon as you paint something, take a picture. Once you fix something in any tangible medium, copyright attaches. My presentation that I'm doing today, staff of the university, this is Copyright University of Maryland. Having a copyright notice helps as well, put others on notice that you're claiming protection for your works. The copyright holder gets the affirmative rights to reproduce, make copies, make derivative works, distribute, perform, display, transmit their work. Copyright, though, does not protect underlying ideas or functionality. Software is an example of something that the code itself may be protected by copyright, kind of as think of it like a work of literature, something in writing. But the underlying functionality, the process that the software carries out, that would be more the purview of patents. Copyright also, there's no requirement to register. As I mentioned, once you write something down, the rights attach, but there are some benefits to registering, and that's through the U.S. Copyright Office, which falls under the Library of Congress in the United States. Copyright lasts a really long time, generally life of the author plus about 70 years, or if it's a company-owned work, then it could be even longer. You might hear discussion of open source software. This is a term that applies to software code specifically, and it's where the author is saying, yes, I hold copyright in the written code, but I'm granting permission to others to take the code, make derivative works, do stuff with it, make copies, distribute, make derivatives, as long as, say, they give attribution. Some open source licenses may have some other restrictions associated, but generally it's a very open, permissive licensing scheme to enable others to copy code without infringing on copyright. This is a link to just a list of the multiple types of open source licenses out there. So if you work in that space and have questions, this is a good place to look at if you're trying to figure out if you want to release your code open source, how to go about doing that. Open source means something different than public domain. Public domain means you're not claiming any intellectual property rights. You're dedicating your intellectual property to the public and anyone can exploit. There's no monopoly on the rights. A trade secret is considered another type of intellectual property, but a little different in that it varies by state. There's no federal registration, and it could protect types of IP that might otherwise be protectable by some of the other types that we've talked about. So trade secrets can protect things like formula, patterns, compilations, programs, customer lists, methods, techniques, processes, pretty much anything that has some economic value that's not generally known and is not easy to figure out what it is. It is a crime to steal a trade secret. To keep something protected by trade secret, you have to take reasonable efforts to maintain secrecy. The recipe for Coca-Cola is probably one of the most well-known, though I think their recipe varies by where it's made. WD-40, how that was made used to be a well-known trade secret until someone reverse engineered it, who didn't steal it, but was able to reverse engineer it. But WD-40, they have a really strong brand name, and that's their trademark. in their name. So the benefit of trade secret is potentially it could last forever. The downside is if someone reverse engineers it, then you lose your trade secret rights. Hard to keep trade secrets here at the university since one of our goals is dissemination of knowledge and publishing, but it potentially is possible. Most, though, of what I work with are patents. Um, Patents protect inventions, and it's usually an invention results from some area of research where you're working on finding a solution to a problem. There are, of course, some accidental invention stories. I think microwave oven, Viagra, silly putty, all things research into something else. And there was kind of an unexpected benefit to whatever the researchers were working on. And those inventions arose from pretty much unrelated work. One story I like is the inventor of Velcro apparently thought of it as he was removing burrs from his dog's fur or his pet's fur after taking a walk in the woods, and then came up with the design of kind of a hook and loop um, fabric and invented Velcro. Um, Patents are something that you have to file, register, go through a whole process through the U.S. Patent and Trademark Office to get a patent right granted. Patents also are country by country. So if you have a patent in the United States, that doesn't give you any rights in any other country. If you want patent protection in other countries, you have to file separately there. A patent is a right granted by the government through the U.S. Patent and Trademark Office that allows the inventor or owner to prevent others from making, using, selling, importing into the country the invention without permission. And this is what's known as a negative right. If you remember, I was talking about copyright, it gives the right holder the affirmative right to make copies, make translations, reproduce, make derivative works. The patent gives you the ability to exclude others from making, using, selling your invention without permission. Patent, this limited monopoly doesn't last as long as copyright. I think the scope of protection is much greater, and so that's a trade-off that you have a shorter time period of having this limited monopoly. And it lasts about 20 years from when you file. There's some extensions, say if your patents are on drugs and you need time to go through regulatory approval, you can get some extensions. Patents in this country, we have three types. When you hear about patents, usually people are talking about utility patents, and this protects processes, machines, articles of manufacture, or compositions of matter, or any improvement to those things. You also have to show that your invention is new, useful, and not obvious. The utility is pretty easy. New, that requirement generally is pretty easy to convince the patent office that what you have nobody has done before. It's that non-obvious requirement that can be a little bit more difficult to overcome. And we spend most of our time sort of arguing, negotiating back and forth with the patent office, showing that our inventions are not obvious. And that means that when a patent examiner gets a patent application to examine, they'll do a search, they'll look at other patents out there, they'll do an internet search, what products are out there, what have people written about. And if the examiner can't find any single reference that describes what you're claiming exactly, but might find two or three that in combination show what you have, you'll get a rejection saying, this would have been obvious to someone of your skill, of ordinary skill in the art, to combine these two or three things in the way that you did to get to this invention. And we rebut that by saying, well, actually, those references taught away from getting to where we did, or it took years of experimentation to tweak it and get it to work like it does, or we got unexpected results that it's so much stronger, faster, better, whatever the case may be. So that probably is what we spend the most time arguing about with the patent office. Plant patents protect new and distinct varieties of asexually reproduced plants. The university has some apple plant patents. We had some raspberry varieties in the 90s. Um, but many universities, especially with ag breeding programs, do very well um, with plant patents. There's a question about do processes like a new financial instrument or delivery of an online service fall under utility? Yes, if your process meets those other criteria, new, useful, not obvious, and is a recognized uh, process that's not just an abstract idea, that would fall under the purview of patents, utility patents. Design patents protect new, original, ornamental design for articles of manufacture. Universities, we certainly don't have many in this area since we're not manufacturing ourselves. Well-known design patents. So the iPhone, they have design patents on the curved corners. They're not straight 90-degree angles, it's curved. They have design patents on that. Crocs shoes have design patents as well. Let's see. Let's go on. There's no more questions there. Parts of a patent. If you ever read an actual patent, it'll give a background, what's the problem that's being solved, a description or a summary of the invention, a detailed description, which is really important. You have to include enough detail where someone else, after the patent expires, would be able to reproduce the invention. That's part of the monopoly deal you get from the government, that you have to give a full disclosure so that someone else, without undue experimentation, can figure out what the invention is, how to make and use it, so that at the end of your 20-year exclusivity, anybody can exploit it. And the idea is that this helps encourage more innovation because people try to then work around what somebody else has already done or improve on what someone else has already done. And then claims, which is a description in very precise words of what your patent actually protects. Often the description of the invention will throw whatever anybody could think of into the description, but what you actually have rights to is just what's in the claims. We talked a little bit about this, the patent criteria. Again, you have to show your invention is new. No one has done it before, including you. It has to be useful and not obvious. Certain things that could prevent you from getting a patent if you publish before you file a patent, if you have your thesis defense that's open to the public, post something online, present at a meeting that's open. You have posters in hallways in buildings on campus that are open to the public, and of course, offer for sale or have for sale your invention. There are some exceptions to this. So in the United States, you have a 1-year grace period for an inventor's own public disclosures, but it's pretty limited. Most other countries, once you have any of these activities, you lose your ability to file a patent. So here at the university, we balance kind of a tension between we want people to publish with we also might want to protect something by patent application. So there are some types of patent applications that we can file relatively quickly and relatively inexpensively as we're evaluating to figure out if patents are something that we want to invest in. Patents also probably are the most expensive type of IP protection to get. Filing fees to the patent office, but it's best to use a patent agent or a patent attorney who knows the process and can advocate on your behalf in filing for the patent office. And to get a single US patent, probably between, I don't know, $15,000, $25,000 to get to issuance for that one patent. And then you have to pay additional fees to continue maintaining your patent rights for that 20 years. Here's one example of a University of Maryland patent that I like to talk about because it's relatively simple, but we met those requirements. That was new, had some use, and was not obvious, even though it was simple. Years ago, we had a faculty member in psychology who's an expert on raptor eyesight, so how eagles, hawks, birds of prey see. And so, when as people, if we're, say, looking at a ceiling fan or desk fan on as the blades are spinning fast, we can't see the individual blades because of motion smear. Well, this is what happens when these birds of prey are flying. They can't see the individual blades of big wind farm windmills against the sky. And there's a problem with avian collisions wherever these wind farms are. So Bill Hodos thought, well, if we paint patterns, colors, designs on the blades in a way that something that we know these birds can see, then they won't run into the blades. And we were able to convince the patent office that this was new, no one had thought to do this before, and we have an issued patent on it. One thing that can get tricky as well in with patents is thinking about who is an inventor. This is different from authorship on a paper. If you work in a lab and you're ready to publish on something, generally, of course, you're putting your advisor's name on the paper as well, anybody else who contributed to. It's a little different though with proper inventorship for patents. So an inventor is someone who contributes to the conception of the invention. The conception, of course, has its own specific legal definition, which is here, and that's having a definite and permanent idea of the complete and operative invention. And it's considered complete, definite, permanent when one of ordinary skill would be able to read what you wrote, reduce the invention to practice without extensive research and experimentation. Joint inventors don't have to work together, don't have to make the same type or equal amount of contribution, and don't have to contribute to each claim in the patent. And inventorship does go by claims. So let's say a patent application is filed and there's claims on a device, there's claims on method of making the device, and then there's claims on a method of using the device. Say someone who is named as an inventor only contributed to that use case. They figured out maybe a new use for this device. If those claims get removed from the patent application in prosecution, as you're doing that back and forth with the examiner, that person then would also need to be removed from being named as an inventor if they didn't contribute to the design of the device itself. And this is important to get right. Who owns IP? This is it varies. Here at the university, we look at who each inventor or author is, what their employment status is at the time the work was done, what assignment obligations they have, what funding was used, what our IP policy says, and if there was any other agreement in place that talks about intellectual property ownership. In this country, we have a law called the Bayh-Dole Act, which lets universities own inventions made with federal funds. So if you're working on an NIH or DoD or what DOE funded project and an invention comes out of that project, the university owns the invention, but the government has certain non-exclusive government purpose rights to use that invention. We're encouraged then to collaborate with companies to license these rights and further develop the inventions to make products. We're encouraged to license to small companies. And we are required to share revenue then that the university brings back for these federally funded inventions that we own with inventors and to further more research activities. So our IP policy lays out how this revenue sharing works. So for inventions, if the university owns it, inventors would receive 50% of income that comes back to the university. The departments, wherever your appointment is, gets 25%. And my office gets 25% um, to help support our costs in administering all of this intellectual property. So our IP policy also supplements what these federal statutes say. Here, I generally tell people that if you're a student and you're coming to the university, you're paying us. Whatever you do as part of your academic research activities, you own. But then if the university is paying you to do something, then the opposite might be the case. Our IP policy groups together inventions, software, data, materials, and then copyright's treated a little bit differently. So the university would own inventions if made in performance of sponsored research, whether federal, industry funds, if there's a company that gives gift money to the university that supports the work as well, that counts as a university administered fund, made for personal purposes using significant university resources without permission. Say there's, a special microscope in a lab that not everybody gets access to. If you use that as part of your research, then that could kick in the university's ownership. But if you're using a resource that kind of everybody has access to, libraries available to everyone. Most people get a computer or a phone, and if you happen to be talking on the university issued phone and you come up with an idea, that doesn't trigger the university's ownership interest. That's not a significant resource. Or if there's some other agreement in place that says the university needs to own the IP, then that's where we would own it. For copyright, so traditional scholarly works, this is like course syllabi, course materials, whether online or traditional face-to-face, lecture notes, literary works, nonfiction books, textbooks, professional articles, presentations, musical scores, dramatic works, photographs, any other artwork, films, all of that falls under traditional scholarly work. So students hold copyright unless the work was created in capacity as personnel. So say you're paid as a teaching assistant or graduate assistant, and you had to create something in order to meet the requirements of your job on campus, then you may not own it, the university would. If it was a required deliverable or created performance of a contract, like there's a report that you had to write to deliver back to the sponsor, works created outside the scope of academic research using significant resources without permission. And this is for really personnel, not students. Or if not, holding copyright would be result in a breach of contract, then the university would hold copyright. So generally, traditional scholarly works, the author holds copyright, not the university. And we kind of have a checklist that helps distill this down. So for personnel and students, if the IP was not created under sponsored research, not created using university or gift funds, not created for personal purposes using significant resources, there's no other agreement in place that gives us ownership, then personnel would own the IP. For students, though, IP that you create in the performance of academic research activities, whether or not you use significant resources, you would own. And there's a link to our full IP policy as well. Rights to use IP. So as the owner, we talked a little bit about this earlier. So patents gives you the right to exclude others from making, using, selling, importing into the country where you have a patent, that invention. Copyright gives you the affirmative right to reproduce, prepare derivatives, distribute copies, perform, display, transmit. Our IP policy also covers data and materials, even if there's no explicit intellectual property right that's associated with those. could be some IP rights, some contractual rights. So as the owner of these things, you may grant permission to others to use some or all of these rights, and that's a license. So think about it, a license like a lease with real property. So if you buy a house and then sell it, once you sell it, you no longer have the ability to live in that house, use it for any reason. But say you own a house and you sublet your basement to somebody else, that's like a license. You're giving someone for limited time the right to exploit, to use this particular space of your property. Exploiting any of these intellectual property rights without permission is infringement. There's a question, you speak to IP rights. If someone's a student but gets tuition remission for being a full-time staff member, maybe I'd need to know a little bit more about what you're doing. I think as a staff member, if you do something in the scope of your employment as a staff member of the university, say it's a university administrative work, this presentation on the staff of the university holds copyright in this. But whatever I would do as a student, even if I get tuition remission, that would not kick in the university's ownership of what I do as part of my research and academic activities. Someone also had asked ahead of time about knowing more about IP rights as an intern within a large organization. So if you're going to intern, say at a company, you're probably signing some sort of employment agreement that assigns all IP rights to that employer, even if it's just an internship of work, inventions, whatever you create under the scope of that work. We do have to be careful here at the university, especially since we allow personnel to consult. Any agreement that you might sign in a consulting arrangement can't conflict with our IP policy. So we want to be sure that if someone has outside employment or is consulting and they're also employed by the university, that they're keeping work separate so there can be no confusion over who owns what IP rights. Some exceptions to infringement. You might have heard the term fair use before, and this is an exception which carves out an area in which individuals other than the owner of a copyrighted work can use that work without infringing on the copyright if it's for criticism, commentary, news reporting, teaching, scholarship, or research. Though there's a very specific analysis of how you figure out if you're copying of somebody else's copyrighted work is an infringement or not. So if you ever have a question, ask. You can go to Office of General Counsel. They might have some guidance as well. But generally, we're looking at the purpose and character of the use, whether it's commercial or non-commercial, the nature of the work, amount and portion used in relation to the work as a whole, and the effect on the potential market value of the copyrighted work. So say you're teaching something and there's like a 3-page section of a full textbook that you want your students to read, but you don't want them to have to purchase the whole textbook because you're not using anything else. If you copy, say, those 3 pages and share them in a class website so that students can read the article, it's a very small portion of the work as a whole. It's not for commercial purposes. That might lean towards that being fair use. But if you scan in the entire 400-page textbook to prevent your students having to buy them, that's probably not a fair use. You're copying in the whole work when they're using the full book.
Oh, you want a lot?
And that could have a potential impact on the sales of that textbook. So these are all things to consider in figuring out if what you're doing with that work is fair use or not. There is no fair use exception for patents. People tend to think that there is if they're doing research. Technically, if you are using someone else's patented invention as part of your university research, if you don't have a license, that's an infringement. Now, it's unlikely that, especially if we're not going to be selling something, um, it's not causing much harm by, say, removing that patent holder's ability to get their own funding or licensing. It could be unlikely that that patent holder is going to come after you and say, you need a license from me, but technically that is an infringement. So we do try to document, say, especially when researchers move from one university to another, if they're continuing research on something that might have been patented at another institution, we want to make sure that institution gives us permission to continue using their patented inventions. So there's no fair use exception for patents. Another caveat to remember, so licensing jointly owned IP. So patents, copyright, these things can be jointly owned as well, especially if you're collaborating with others elsewhere. For patents, though, if there's multiple joint owners, each joint owner can exploit rights non-exclusively without having to share money with the other joint owners if there's no agreement. But copyright, there is a duty to account. That means if a work has joint authors, it's jointly owned, and someone is selling it, they have to share that revenue from those sales back with the joint owner, joint authors, in proportion to contributions to the work, and that can get a little messy and complicated. So I always like to have agreements up front that make clear how joint works, joint patents will be handled. Pay attention to license and assignment language in contracts. We talked about internship agreements. Read what it says before you sign it. If you're worried about it, don't know what it means, then ask somebody who can help explain it to you to consider if it's in your best interest or not to sign it. Employment agreements also might have things like non-compete clauses in it that might say for a certain amount of time, even after you leave employment with that company, you might not be able to work in the same area of research, certainly can't take what you've done at that company to another company. Non-disclosure agreements might have some tricky language in it as well regarding IP rights and ownership. Even when you're submitting, say you have a thesis and then it's being broken up into multiple publications and you're working with different journals, make sure that rights you're signing over to those journals to publish the paper align with whatever rights and agreements you've signed to get your thesis published. You want to make sure that IP terms are consistent and don't conflict in any way. Back a little bit to what my office does. So we take in intellectual property disclosures on behalf of the university. We evaluate, we do the marketing, licensing, try to find commercial partners who can further develop very early stage ideas and other intellectual property that we get. We provide support for startup companies. If someone wants to create a company around intellectual property made at the university, we ensure those IP rights. So we have free patent attorneys who manage all of the patent work. But also we protect copyright, some trademark work as well on behalf of the university. I mentioned before what the government's rights are for federally funded inventions. That comes with a whole host of requirements and responsibilities that we have then to the government. And that takes several people to make sure we're in compliance with all of those requirements. And then handling revenue distribution. So when we receive funds, income from licensing of IP, then we have to administer that and distribute it according to our IP policy. A question about, does patent support extend to students whose IP the university would not own? So not through our office. So you have the option of going through us. even if you're not required to, if we don't own it. We could talk about pros and cons of doing that. If someone chose to assign to the university, even if they weren't obligated to, then we would treat you like any other inventors under the IP policy. And then the benefit is the university pays for the patent costs, and does all the legwork with licensing. But there's some other resources available. If the university does not own the IP, and you're looking for some other help, so the University of Maryland School of Law has an IP clinic that's staffed by law students who are supervised by practicing attorneys, and they can help with trademark, patent filing, limited scope. There's also another nice pro bono resource in the state of Maryland called Maryland Volunteer Lawyers for the Arts. And they have a network of attorneys who volunteer their time to help with some basic contract work, trademark, and copyright. Our office, UMVentures, we're in the basement of the Lee Building next to main admin. And we also have space behind the hotel, Startup UMD, behind the hotel garage on your way to the hall. Let's see. Creator responsibilities, always advise, please keep good records, keep lab notebooks. I know that's not so common in many areas of research anymore, but keeping good documentation over your work, showing this is your work, here's what I did, here's when I did it. That can often be really good documentation when you're trying to show it's your invention. Keeping track of written communication too, if you're sharing with others outside of the university, having documentation of what you shared when can help us figure out if we have IP rights or not. Obtain applicable permissions when you incorporate third-party works into your own. So if you need a license from somebody else, get that permission. If the university owns it, you're required by policy to let us know about it. Even if something is not, you don't see a commercial use case for it, but if you have a funding agreement that says the sponsor needs to know about inventions, you still need to tell us about it, let us know, here's what you think about it, but we need to disclose it because it was made under this sponsored research award. So make sure you're timely disclosing. Help us if we do move forward on a patent, help us in the patent process, update us on public disclosure activities that could compromise patent rights. And can't stress this enough, formalize research collaboration agreements, excuse me, that you have with people at other institutions. Many research relationships always start out good and collaborative and collegial, and often things can go downhill fast. So having a formal research collaboration agreement in place, even if it's just a non-disclosure agreement, just to get a conversation started, can be really helpful as we move forward. And remember, getting a patent does not equal commercial success. I look at patents as a tool to helping add value to an idea or an innovation that would get someone else interested in it, especially if you go a startup route. It's a tool that adds value to your company that investors would like to see. Disclosure to my office does not equal an automatic patent. We have to go through an evaluation to make sure that, one, will it meet those patent requirements? And is anybody going to want this? Is anybody going to pay for it? We have a limited budget, and so we often have some tough decisions to make if we're going to pursue patenting or not. There's a link for our disclosure form. I mentioned the Maryland Volunteer Lawyers for the Arts. There's a link, and I think the IP clinic, if you're interested and need their assistance, there's an email address there. And if you go to the IP clinic, this is with the law school, and you indicate you're a University of Maryland College Park person, they'll come back to me to check that we don't own it. Because if it is College Park owned, you have to go through my office. But if it's not, then we can say you're free to work with the clinic. And I think that was all I had. Any other questions, things you were hoping I'd talk about today but didn't get to? How best to make an appointment? Send an email. We have, if you want to meet with me individually, yeah, send me an email. Or if you're not sure who to talk to, UMD Tech Transfer, put that in the chat. Thanks for all the questions, Tara.
I thought I just asked the next one too. Do you
Yeah.
prefer to have like a two-page write-up on what this is? Do you just want to first go through whether or not we own it and you don't really care what the idea is?
Yeah, I think if you're trying to figure out first if it's something that you do need to disclose or not, yeah, I would say just start with a phone call and then we'll take it from there.
Great, thanks.
Sure.
Well, thank you so much, Felicia. You did a wonderful
Sure.
job. I I've watched this like 3 times now, and over the years, and I still learn things every time. So I really appreciate how thorough you are, even though it is top level. It's still very thorough, and you did a great job answering their questions throughout. So they didn't really have many at the end. But thank you to everybody who is here with us today watching, and thank you to anybody who watches in the future. For those who were here today or who did register, we'll be sharing the link to the video tomorrow and sending out an evaluation form, and we'd love it if you were able to follow up with us on that evaluation, although I know it's going to be glowing like it has been in all the previous years. But thank you again for all your time and sharing your knowledge. Thanks, Felicia.
Sure. Thanks, Zach. All right. Have a good day, everyone.
Thanks. Bye.